Hello, good morning to all of you. I, Dr. Tabrez Ahmad, welcome Dr. Pavan Duggal and the students, faculty, lawyers, friends, and all the other participants in the webinar on an important topic. What increasing cybercrime and cybersecurity scenario during COVID-19 are teaching us. Organized by School of Law, GD Goenka University. In association with Policy Times and GD Goenka Uplearn Academy, promoting specialized webinars for specialized learning during crisis. In today's webinar, we are having conversation with Dr. Pavan Duggal, the Honorary Chancellor of the Cyber Law University and Advocate, Supreme Court of India. He is an internationally acclaimed authority and well-known figure in the field of cyber law. He is expert on cybercrime, cybersecurity law, artificial intelligence law, e-commerce law, and various other linked law of the cyber area. He is board member of various committees like artificial intelligence, globe ethics, etc. He is advisor and consultant to various international agencies and policy-making bodies of European Union, ICANN, UNESCO, United Nations, UNDP, and WIPO, and also International Court of Justice, to name a few. He has founded the Cyber Law University around and conducts 21 different online courses, which have been subscribed by more than 17,000 students from 165 countries, speaking 46 languages and excellent ratings. He has immensely contributed and proved to be a moving spirit in the cyber law framing of India and various foreign countries. He has an academic bent of mind and published more than 130 books and spoke in more than 2,200 conferences. Dr. Duggal has been acknowledged as one of the top 4 cyber lawyers around the world. We are feeling extremely honored and privileged that Dr. Pavan Duggal has accepted our invitation and has found time from his busy schedule to have a conversation with us on the very important area of cybercrime and cybersecurity. We welcome you once again in the webinar.
Thank you, Tabrez. It's a pleasure and an honor that you have invited me. One would be delighted to be a part of the deliberations today.
Okay. As per the reports, the cyber crimes has doubled, and we have seen fast increasing cases of cybersecurity breaches during the coronavirus pandemic, COVID-19. There are infrastructure challenges of collection of electronic evidences and lack of electronic courts, lack of awareness of people, and lack of training to police personnel, and lack of cyber police stations. The current cybercrime conviction rate is around 1%, which has no deterrence on cyber criminals. So my first question is that what should be done to reduce the cyber crimes and raise the conviction rate in cybercrime cases?
Well, Professor Ahmad, one thing is very clear. We are seeing a metamorphosis where the cybercrime volumes and the cybercrime categories and the manifestations are constantly growing. Now, during the national lockdown period, I call it the golden period for Indian cybercrime, primarily because the way and the manner and the growth with which cybercrime grew in the country in the last 2 months of the national lockdown has been unprecedented. We haven't seen similar kind of cyber criminal activities ever since internet was commercially introduced in the country on 15th of August 1995. When I look at the conviction rate, I find that we are extremely lagging behind. But then we are in good company. Even countries like US and UK do not boast of very, very strong cybercrime conviction rates. One of the main reasons in this regard primarily relates to the fact that in our country, first and foremost, there are various challenges in getting a conviction. The first challenge is trying to get a case registered. In a majority of the times, we find that the police is not willing to register your cybercrime complaint. And even if they acknowledge it, they would only give it a DD number, but would not register a first information report. So we did a survey a few years back, and we found out that for every 500 instances of cybercrime that take place, only 50 tend to get reported, and out of 50, only 1 tends to get registered as an FIR. And I think those were very, very conservative figures. Today, the situation is far, far worse. But the first challenge is getting an FIR registered. Second is the entire challenge pertaining to detection, investigation of cybercrimes, and collecting the relevant incriminating electronic evidence. That's a big, big challenge because most of the time, The police is not invariably able to do this in a flawless manner. They will either consciously or unconsciously leave behind various kinds of loopholes which can potentially be exploited by the accused during the prosecution of the cybercrime. The third biggest challenge in getting a cybercrime conviction is retaining the incriminating electronic evidence that's been collected in a manner that's as prescribed under the Indian Information Technology Act 2000 and the Indian Penal Code. Most of the time, the electronic evidence is invariably collected and kept in malkhanas with no clue on how the Information Technology Act 2000 wants this particular electronic evidence to be protected and preserved. The fourth biggest challenge is how do you produce and prove the said electronic evidence as electronic proof in a court of law once the prosecution is going on. This is a bigger challenge ever since the judgment of the Supreme Court in Anwar PV versus PK Bashir came across. Now that judgment is currently being reviewed by a 5-judge constitution bench, but till such time the constitution bench does not really come up with a new judgment, the law under Anwar versus PK Bashir prevails, which means that for any electronic evidence or any computer output that you will have to produce or prove, you will have to comply with the mandatory requirements of Section 65B of the Indian Evidence Act, which means that you will have to give a certificate. Most of the times, the certificate is not given as per the parameters laid down in Anwar versus Bashir. With the result, it's often defective. Sometimes the certificate is given properly, but the witness is not able to withstand a very, very strenuous technical cross-examination and would invariably collapse. So trying to prove electronic evidence itself becomes a big challenge for law enforcement agencies. And finally, even if you do that, the biggest question will be how do you create the attribution nexus between the commission of the said cybercrime and the relevant person or the actor who has done the same. And invariably we find that there are big challenges. And I think overall, the biggest challenge is we need to do far more capacity building. Most of the time, the judges who are listening to these matters are not very well attuned to so as to really appreciate the finer nuances of cyber crimes and for electronic evidence. In addition, I think there's need to be massive capacity building, both amongst the law enforcement agencies and well, it appears there is some kind of a technical glitch, and that's the reason why there was a slight break. But nonetheless, we will await for Professor Tabrez to join us as we continue with this fascinating journey of how cybercrime and cybersecurity breaches are going to be the new normal as far as we are concerned. In fact, I can see that there are various people who are attending this particular webinar, and you could all potentially also see various kinds of scenarios. We'll have to just wait while I believe Dr. Tabrez should join us.
I think we lost the connection.
Yeah, I think we got lost in between. So I don't know where we lost, but I was talking more about various challenges for cybercrime convictions. So we talked about challenges pertaining to registration of an FIR, pertaining to collection of electronic evidence, pertaining to retaining it properly, proving it, And then finally, they focus on compliance with the parameters of Anwar versus Bashir. And finally, I had focused on the need for far more capacity building amongst the judiciary and law enforcement agencies in order to for enabling India to improve their cybercrime conviction rate.
Okay. So my next question is that cyber criminals are very smart and generally they hit from the safe places. And one of them is Jamtara in Jharkhand, which is known to the enforcement agencies, but still there is no control. What do you suggest about this?
Well, Jamtara represents an island within a country, primarily because it's the cybercrime island of India. It's that particular area where every person in Jamtara is somewhere connected with either the commission of various kinds of cybercrimes. In fact, that village has actually shown the entire world how innovativeness can be used for the purposes of targeting innocent, young, trusting people. And I believe that because there is a Jamtara and because there is now increasing awareness about Jamtara, the country needs to specifically focus on these kinds of cybercrime havens. Well, it was also said at earlier point of time that trying to catch these people were difficult. But now that we know a particular location, I believe what ultimately is required is far more decisive action by the law enforcement agencies. Even one of the OTT channels have now a particular serial by the name of Jamtara. And I think Jamtara is only the tip of the iceberg. What I'm actually now seeing is that there are smaller Jamtaras that are coming across in different parts of the country. In fact, cybercrime is slowly percolating itself as a cottage industry in the country. It's going down to tier 2, tier 3 cities and even to rural or semi-urban areas, primarily because cyber criminals have understood that the law enforcement agencies at the relevant levels do not have the wherewithal to go ahead and identify and even reach out to these cyber criminals. So I believe, despite there being a Jamtara, we've not been able to take very effective kind of remedies. We should be able to take that. In fact, the government needs to take specific action to ensure that things like Jamtara don't exist. Because things like Jamtara exist, the normal people feel that, the law is not doing what it's really required to be doing. And in fact, when I look at the Indian cyber law, I find it a toothless wonder in the context of trying to control cybercrime because of the historical mistake that India had made way back in 2008. It was that very historical mistake which has now propelled the existence of elements like Jamtara and other tier 2 or tier 3 city cybercrime syndicates. And that historical mistake was when we had passed the Information Technology Amendment Act 2008, which made a substantial departure from the IT Act of 2000. That amendment categorically said that, look, we are now going to make almost all cybercrimes, barring 3 cybercrimes, as bailable offenses. So once you started creating almost all cybercrimes as bailable offenses, you started giving a message that the law is going to go soft on cybercrime. Well, we tried to increase the quantum of fines. The fines went up from 1 lakh to 10 lakh rupees. However, that did not have the salutary deterrent effect. And that's the reason why a lot of people in India actually have a direct connection between cybercrime and the Indian Jugaad school of management. Indians believe that because the Indian law is very inadequate, they could use any kind of Jugaad and they could go ahead and manipulate the electronic evidence or destroy the same, and therefore also ensure that they do not get convicted. So I believe that complacence factor that's come in, that needs to be shattered by means of new legislative amendments to the law and coming up with very strong enforcement of existing provisions of law. Thanks.
Okay, thank you for a nice answer. My next question is that it is said that data is a new oil and refined data is a refined oil. The multinational companies and political parties are encashing the benefits at the cost of public at large. What is your view of data localization and data analytics, especially in the backdrop of Cambridge Analytica case?
I think the flavor of today's times is data localization. Look, till such time, the GDPR or the General Data Protection Regulation had come in, data localization winds had not yet begun to start flowing in. But just about the same time, we saw both Russia and China coming up with national laws on data localization? Well, it all began with Russia, who said that, look, in case if you want to do business with Russians, please ensure that the data of Russians is physically located within the territorial boundaries of Russia. Now, logically speaking, when I look at internet as a seamless network of networks and this entire existence of cyberspace, I realize that it's one medium where there are no boundaries. But very quickly, countries have begun to start installing artificial boundaries in cyberspace. And that's the reason why countries have begun to start realizing the immense value of data. Yes, there is no denying the fact that we are in the data economy. Yes, there is no denying the fact that internet has transformed all of us into being global authors, global transmitters, and global broadcasters of data. If that being the case, we are constantly generating data. And if entities like Facebook or Instagram or Twitter are respecting us, they're not respecting us because we are individuals. They're respecting us because we are generating data for them on a 24/7 basis. Now, this is the massive importance of data that countries have slowly woken up to. Like countries like India are saying, look, the entire data of these Indians, 1.3 billion population, or the netizen users connected therewith, is all flowing outside the territorial boundaries. And it's very important for protecting the cyber sovereignty of the country that the data must be physically located in the country. Well, I believe that has got both positives and negatives, but that was pre-COVID times. Come COVID-19, and I think the scenario has changed completely. Countries who are just sitting on the fence whether they would want to go for data localization or not are now increasingly clear after the advent of coronavirus that data localization has to be an important ammunition in the arsenal of any country so as to protect its cyber sovereignty. So I believe that though it's not very good that you should have data localization, but given the fact that how COVID-19 has completely demolished the phenomenon of globalization, I would be seeing more and more trends of countries coming up with specific national laws on data localization. When I come to India, I find that Indian approach has been best prior to COVID-19. Well, first we had the thought process, which we said, the government said we wanted you to get your data within India because we wanted to be physically located in India. And then we saw the new draft of the Personal Data Protection Bill, which was filed before the Parliament in December 2019. Now that bill substantially had watered down the earlier governmental stand by saying that, look, we are okay if you keep the data of Indians outside. We will be happy if you just give us a serving copy within India. Now that was a self-defeating exercise because that was a complete watering down of the data localization norms. But I think that was December 2019. Today, as we go to the end of May 2020, and with the coronavirus infections increasing, as and when the government gets time to look at this issue, I believe that they would increasingly be more inclined in ensuring more prescription for data localization. Ultimately, in today's scenario, when coronavirus has given a death blow to globalization, different countries are increasingly going to make their state powers, the roots far more stronger. And I think what better way to strengthen your roots, your cyber sovereignty, than to ensure that your data is physically located within your territorial boundaries. Actually speaking, I'm actually beginning to see a new cyber world order that's begun to start emerging. We were all being so busy in trying to fight coronavirus, in trying to protect ourselves, that we forgot seeing some major developments that were taking place below the horizon, below the surface. And that was these new developments where states are getting very powerful. And this is going to come to leading to a new cyber world order once the fight against COVID-19 comes to an end. This will be a new world where there'll be completely changed ground realities. Well, in the last 24 hours, President Trump has now come up with a new executive order for social media companies. So the mill is slowly churning, and the entire issue on intermediary liability is once again getting center stage attention. But I believe countries will increasingly have to look at a variety of different elements so that they can use those elements for the purposes of, again, protecting the national interests, protecting the interests of their citizens, and also protecting their cyber sovereignty. Thanks.
My next question is that there's a big political game is happening globally by promoting fake news. It was more rampant during the coronavirus pandemic. And how to ensure the authenticity and regulate it?
Fake news has emerged as one of the biggest challenges that the world has seen uh, after the coronavirus actually evolved and started growing. In fact, I believe the advent of COVID-19 has seen a trinity of sisters. These are three major trends that we've begun to see in cyberspace. The first, increasing cybercrimes, uh, whether it's phishing attacks, whether it's identity theft. The second sister is increasing cybersecurity breaches, not just on normal networks, but also on health networks and on energy grids. Well, last week we had the Oxford Cyber Statement, of which also I'm a signatory, which has actually called upon various nation states so as to ensure that they should absolutely work in the direction of not having any cyber attacks on the health or the medical infrastructure of any country, because that could prejudicially be impacting the rights of people. And the third trinity, of course, is fake news. Fake news has grown with enormous proportions, specifically in coronavirus. Uh, Actually, coronavirus times came up with an atmosphere of fear and panic. So cyber criminals started weaponizing this fear and panic. And consequently, they started not just publishing, but also disseminating all kinds of fake news under the garb of COVID-19 or coronavirus. A majority of these fake news could either be in the form of phishing attacks. These could be phishing SMSs, phishing emails, phishing messages, where they're telling you that if you want to have the latest update about COVID-19, click on this link or download a particular attachment. And once you do the same, your entire system gets compromised and your data gets prejudicially impacted. We've also seen some massive circulation of all kinds of completely fabricated or manipulated news. In India, there are two figures which are available in the public domain. The state of Maharashtra, as per one figure, or as per one report, has registered more than 500 cases pertaining to misuse or of social media in the context of dissemination of fake news. Further, there's yet another report which talks of another 400 cases being registered in the country in the context of fake news. So fake news is going to be of immense challenge. It's not only going to further continue to keep on terrorizing, threatening people, making them panicky, but more significantly, it will also be used as a very effective means for the purposes of diminishing the trust of the people within their government. And for that, I think ultimately you would require strong, dedicated legal frameworks. Unfortunately, at the time when we talk today, India does not have any dedicated legislation on fake news. Much like, unlike countries like Malaysia or Singapore, who have now come up with a dedicated law on fake news, so much so France has now come up with new legal frameworks so as to regulate fake news. In our country, in India, unfortunately, we are still trying to cover fake news under the IT Act, which technically we cannot completely cover. Yes, some portions of fake news can be said to deprave or corrupt the minds of people who are likely to see, read, or hear the same. So you could potentially bring some elements of fake news within the ambit of Section 67 of the Information Technology Act 2000, but that's a very, very inadequate or incomplete coverage. Though we do have Section 468 and 469 of the Indian Penal Code. Under Section 468 of the Indian Penal Code, whenever somebody creates fake news, he's forging electronic records and thereby creating forged electronic records for the purposes of cheating. This is a serious offense, gets punishable with 7 years imprisonment and fine under Section 468 Indian Penal Code. In addition, in case of the fake news is specifically focused on targeting the reputation of a particular person, then we could definitely also invoke the provisions of Section 469 of the Indian Penal Code in terms of electronic forgery for the purposes of harming the reputation of another. But I've seen, practically speaking, the police are very hesitant to go ahead and even register these cases under Section 468 and 469 of Indian Penal Code. 21st of March, 2020, that is the day the advisory was issued by the Government of India, by the Group Coordinator Cyber Law, whereby request was made to all the social media companies to ensure that all kinds of fake news is not disseminated or transmitted. Now, that was a mere advisory. That's not very happily drafted moment, primarily because the government is not in a requesting mode. The government has the power to mandate these social media companies to ensure that no fake news is disseminated on their platforms, thanks to the specific power given under the Section 87 of the IT Act to the central government. Well, it's important to note that till today, the government has not yet come up with any dedicated rules and regulations for regulating fake news, which I believe they can do immediately under Section 87(2) of the Information Technology Act. But ideally, as I go forward, I'm very clear that because fake news will ultimately start prejudicially impacting the security, sovereignty, integrity of the people of India, or the confidence of the people in the government will have to very quickly come up with a detailed legal framework, dedicated law on fake news, so that a message of deterrence can go. Today, there's no stopping anyone for creating anything false. And today, because people are afraid, they are panicky, they're likely to read any specific message they get and immediately disseminate without even trying to identify the authenticity or veracity of the same. So legislation is one issue. Second will be more effective enforcement of the new legislation as when it comes across, apart from enforcing the current provisions of law. And finally, I think far more capacity building will have to be done amongst the various stakeholders. I believe all people need to be sensitized that they do not need to be pawns in the hands of fake news syndicates. We should not routinely, mindlessly, without application of mind, forward any content just because it's appearing to be urgent or it looks immediate, without even identifying the authenticity or veracity of the same. So a lot of cumulative efforts and strategies will have to be adopted. Otherwise, fake news will continue to be one of the biggest challenges that India will face in the cyber world space. Thanks.
Thank you. My next question is that generally we talk about the ClearNet, which is hardly 4%, and it is highly regulated. The Darknet and DeepNet is around 96%, and almost all the serious cyber crimes are committed from the Darknet. How to control and regulate the Darknet?
That's $1 million question, Professor Tabrez, primarily because the world still doesn't have the answer to the question of how do we regulate the Darknet. Well, Darknet is that space of the internet where you cannot go using a search engine. You have to use a specific browser known as the Onion Router browser or the Tor browser. Once you use the Tor browser and go on to the Darknet, you're anonymous. Everybody else is anonymous. Cybercrime is a way of economic activity, and all kinds of illegal or criminal activities that you can think of are taking place on the Darknet. Increasingly today, more and more cybercrimes and cybersecurity breaches are getting originated from the Darknet. Last almost a fortnight, we've seen two major news stories pertaining to Darknet. One, that there was 2.79 crore data of Indians that was just made available for sale free of cost on the Darknet. And then we had a recent another news which talked about numerous crores of Indians data of Truecaller, which had been made available for just about $1,000 for sale on the Darknet. So I believe when this kind of an ecosystem is existing, where the architecture of the Tor browser does not allow you to really identify the attribution of the particular cyber criminal activity to a particular cyber actor, I think there are immense challenges. So that's the current position, but the reality is that various stakeholders have started working in this regard. Interpol has already started coming up and is now conducting a new training program on how to detect and investigate as also prosecute cyber crimes on the Darknet. Technically speaking, Darknet is ultimately nothing but use of computer systems and computer networks as also electronic data. So broadly speaking, it can be argued that Darknet is covered under the existing national cyber laws, but because national cyber laws do not have specific provisions on the Darknet, there will be practical difficulties in terms of effectively enforcing the provisions of your normal and national cyber laws onto the Darknet. I believe, look, today, specifically during the COVID-19 times, most of the people have started going on to the Darknet. The new cyber world order that's coming in, and that we will see after the end of COVID-19, will see a massive migration of legitimate users onto the darknet for all kinds of legitimate and illegitimate purposes. People are moving on to the darknet because they do not want their governments, their countries to start going ahead and intercepting them, monitoring them. But more significantly, I think as we move forward, countries will quickly start realizing that they're not necessarily concerned with the legitimate activities on darknet. It's only the illegitimate activities of how those need to be regulated will have to be specifically focused on. Well, the Silk Route case that took place in the US was only kind of had a connection with the darknet, but there it was more got to do with social engineering that and collection of other evidences. I believe as we go forward, an institutional legal framework will have to be developed on how to regulate the darknet, but that's the biggest challenge because the population in the darknet does not want to be regulated. The architecture and the service providers of the browsers and the various services of the darknet do not want to be identified, nor do they want to identify any of their existing customers. So I believe this tug of war is going to keep on happening. But as we go forward, and as now increasingly cyber crimes and cybersecurity breaches are originating from the darknet, which are targeting not just individual companies, but also countries and their critical information infrastructure, countries will sooner than later be required to come up with new legal frameworks which can effectively be enforced in the context of darknet. Thanks.
Thank you for a very elaborate and very valid answer. My next question is that, see, most of the big transactions in internet are happening in Bitcoins, and India government has not yet given the clear picture. Neither they are banning nor giving approval. What is your view about these Bitcoins? Whether we should legalize or we should keep kind of not approving it? And what should be strategy for the India government on this point?
I believe India has been in a confused state of mind as far as cryptocurrencies and Bitcoins is concerned. Well, and I believe the Indian approach is more like closing your eyes to the sun, which is waking up and which is going up stronger and stronger. See, merely because a country says that I want to ban cryptocurrency does not mean that cryptocurrency is going to go away. My thought process is that cryptocurrencies are the digital present and are the shining digital future. I'm not necessarily saying which horse will be the winning horse. Whether it's Bitcoin, whether it's any other new crypto currency, it's hard for me to predict. But by and large, the paradigm of cryptocurrencies are here to stay. When I look at the darknet, I find that the Bitcoins is the de facto only mode for making major payments for all kinds of cyber criminal activities done on the darknet. So in a scenario like this, I believe cryptocurrencies are here to stay. They will be the foundation for further growth of the data economy as we go forward. But I believe India has historically missed the bus as far as cryptocurrencies is concerned. I've been working with Belarus on their cryptocurrency legislation. And I can tell you that if a country like Belarus can come up with this crypto asset legislation, which is one of the cutting edge legislations, I see no reason why India cannot also walk the walk in the direction of appropriately regulating cryptocurrencies. Look, the RBI circular which said, look, all kinds of banking services will not be made available to those engaging in crypto assets and cryptocurrencies was a historical blunder. The Supreme Court set aside the blunder by saying, look, on level of proportionality and other principles, they found that that circular had to be struck aside, which means that today, if you want to go to a bank and the bank, you ask for banking services while dealing with crypto assets and currencies, they should not normally refuse. But the practical scenario is that today also, because most of the banks are confused, they will ask you to come tomorrow, day after, they want to get some approvals from their heads and stuff like that. I believe the time is now right for India to come up with a detailed legislation on crypto assets and cryptocurrencies. In fact, we could just cover cryptocurrencies under the broad concepts of crypto tokens or crypto assets rather than currencies per se. We'll have to quickly start recognizing that this is a legitimate way, which has already been granted legitimacy in various jurisdictions. Because India had actually gone ahead and banned Bitcoins, we quickly started seeing that a huge chunk of the investor community who was actually working on various aspects of Bitcoins actually transmigrated their operations to other jurisdictions. So India's loss was Singapore, Dubai's gain. And I believe we need to learn from our mistakes. Rather than saying that we will ban cryptocurrencies, a better approach will be say, look, we would like to regulate cryptocurrencies. We would like to potentially even generate some money from the Indian market. And why not? If the cryptocurrency economy system has to grow, it has to contribute ultimately also to the economic growth of any country. But as of now, we don't appear to be seeing anything. The Supreme Court judgment was a great watershed moment when it said that the RBI circular was illegal. But I believe, when I look at holistic point of view, the circular might have been quashed, but the Supreme Court judgment ultimately was a vindication of the power of the RBI. Now, thanks to that particular judgment, though that RBI has lost that particular case in the judgment, but it has emerged far more stronger as it's become the de facto only authority to deal with all aspects pertaining to cryptocurrencies in the country. So I think going forward, onus will be both upon the RBI as also on the government of India, so that they can come up with strong legal enabling frameworks. Let's try to learn from international exposures and experiences. You see, if you specifically look at the cutting edge work that's been happening in cryptocurrencies legislation and regulation, whether it's Estonia, Switzerland, whether it's Belarus, or even Malta, I think our eyes are going to be opened up. Malta is the blockchain island of the world. In the last 2 years, it's come up with 3 distinct legislations on all kinds of blockchain and cryptocurrency related issues. If we can start taking the best international best practices from these kinds of legislations and then start Indianizing them, customizing them as per the peculiar requirements of the Indian ecosystem, that could ultimately go a long way. But in case if you're going to be in an ambivalent approach to say, I'm going to close my eyes and I'm going to wish these cryptocurrencies go away, they're not going away. They're going to get more stronger, more foundational in their contribution to the digital economy in the coming times. So I think as a country, we should be far more proactive in coming up with a more enabling legal frameworks so as to deal with crypto assets, blockchain as a whole. Thanks.
Thank you for very valuable and very detailed answer, Dr. Duggal. My next question is that as the artificial intelligence is coming in a big way and it can be used for cyber crimes, how to fix the liability in the cases of AI-led crimes?
That's a great question, Professor Tabrez. But the fact is, the law is evolving as the time when we talk. Because, yes, AI has begun to start being deviant. We did see the case in the International Space Station, where the AI program started getting deviant and started warning the astronaut that he better needs to be careful and not be rude while talking to the AI program. The program had to be shut down, but that incident was a wake-up call to see that, look, AI is now going to be at some point of time superseding human intelligence. Whether it'll be 2061, whether it'll be 2040, 2035, I can't say. But the tipping point is coming quicker. But when you are now beginning to start seeing a new trend on the Darknet, where all kinds of Darknet sites are actually advertising that they are using artificial intelligence for committing various cyber crimes, the time has come for us to start developing legal norms of how to fix liability for AI cyber crimes. Now, once an AI commits a crime, there are 2 kinds of possibilities in that regard. Number 1, the criminal activity could either be done by the artificial intelligence program, or number 2, the criminal activity could be done by using the medium of the artificial intelligence algorithm. Either way, the responsibility will have to be fixed. Now, you can't send artificial intelligence to jail. That's not possible. But yes, you can definitely regulate AI by trying to regulate the people who are creating the relevant AI algorithms. So somewhere down the line, the legal liability will have to be affixed both on the person who's the creator of the AI algorithm. It will also have to be fixed to some extent, lesser extent, to the person who's the licensee or the user of the said AI platform. Because at the end of the day, the algorithm must be properly programmed in such a manner that as far as possible, it should not be doing any activities which are in contravention of existing law. But unfortunately, at the time when I'm talking with you, the entire principle of legal liability for AI cyber crimes is still evolving. A lot of work is happening in Delhi. We have created the Artificial Intelligence Law Hub, which is looking at and doing cutting edge research on the legal principles that need to be made applicable in the context of AI and its liability per se. But even when I take you to the state of Illinois, on 1st of January 2020, the state of Illinois became the first state in the US to come up with a dedicated law on artificial intelligence. It's called the Artificial Intelligence Video Interview Act of 2020. Now, that's on a very, very limited point. It didn't talk much about the legal liability for cyber crimes. But increasingly, there's information in the public domain that work is happening in China on trying to develop the norms for the various developers and the service providers for AI. I think as time passes by, the legal principles for regulating AI cybercrimes will have to be evolved, and the appropriate responsibility will have to be affixed. The developer can no longer say that, look, I developed AI, I didn't know, I didn't think, and I didn't perceive, or I didn't foresee, and therefore I can't be made liable. If you are creating AI algorithm, it's going to be intrinsically an element of your due diligence that you will have to ensure appropriate parameters are installed therein, that the said algorithm cannot be used for any activities which are in contravention of the law. But I think very exciting times. We'll have to wait and see how further legal jurisprudence in this regard actually evolves. Thanks.
Regarding this, there is a lot of rampant hate speech on the internet and WhatsApp and all. And sometimes people feel they're justified to use as a freedom of expression. So what is the final balance and what is the dividing line between the hate speech and freedom of speech and expression as a fundamental right?
I believe all of us have a fundamental right to freedom of speech and expression. In India, that right is enshrined under Article 19(1)(a) of the Constitution. But unlike other fundamental rights, it's not an absolute right. It can be subject to certain reasonable restrictions under Article 19(2) of the Constitution of India, which can be so imposed by the state in the interest of sovereignty, security, integrity of India, friendly relations with other nations, public order, decency, morality, or to prevent the commission of any cognizable offense. So in case if you think that your freedom of speech and expression includes the freedom to go and conduct all kinds of hate speech related propaganda, then I think you're mistaken. Appropriate restrictions can be put on your fundamental right of freedom of speech and expression. Now, when I look at the various jurisprudence of the judgments of the Supreme Court clearly says that you cannot go ahead and state anything which is going to disseminate more hate or which could ultimately destabilize the public order. Ultimately, when I even look at Section 79 of the Information Technology Act, I find that the law says that these intermediaries or network service providers, including social media companies, will have to exercise due diligence while discharging their obligations under the law. Further, when I take your attention to the Information Technology Intermediary Guidelines Rules 2011, those rules specifically mandate these various service providers to have in place detailed rules and regulations, terms and conditions that specifically stipulate the users not to use the platform of the service providers for uploading, hosting, or publishing or transmitting any content which could either be against the law or which could actually be prejudicially impacting public order, and which could include elements of hate speech per se. But unfortunately, today in this ecosystem where we are standing, people somehow get a feeling that because cyber law has not been very effective, I can get away with murder. I can engage in any kind of hate speech. And in any case, these are special coronavirus times. The government is busy fighting corona. So who's going to catch up with me? I think that mindset needs to be changing. You have to quickly start realizing that the internet as a paradigm never sleeps. Internet as a phenomenon never forgets. So whatever you're going to publish online is going to be there for a long, long period of time. Yes, today, the government or its agencies may be busy in fighting coronavirus. But once there's incriminating electronic evidence against you, which talks about your engaging in various kinds of hate speech activities, then potentially action can be taken against you under various laws of the country, whether it's the Indian Penal Code, whether it's the Indian Information Technology Act. But ultimately, I think we will require far more nuanced approach, because who's going to determine what is hate speech? Is calling a member of a particular community hate speech? is making a casual reference to somebody hate speech. I think the parameters of hate speech in the context of cyberspace have not effectively evolved. And I think all eyes will be now on the Supreme Court on what kind of new parameters and approaches it should potentially guide us as to determine what potentially could be actually said as hate speech online and what kind of balancing factors need to be done. But law is only going to play a very, very small role. A bigger issue will be more on capacity building. We will have to start creating a sense of capacity building amongst digital users that they should not be publishing content which tantamounts to hate speech, because this kind of hate speech is not just going to prejudicially impact the fabric of the Indian society and the nation, but more significantly could ultimately even have a prejudicial impact upon the security, sovereignty, or integrity of the country. So I believe we should have dedicated legal provisions on fake news, on hate speech. Unfortunately, the IT Act doesn't have that, though we do have some provisions under the Indian Penal Code to deal with the same. Thanks.
Thank you, Dr. Duggal. Recently, because of this coronavirus pandemic, people have shifted to online education, online classes, and then we subscribed mostly the cheaper kind of the platforms. And one of them being Zoom, people have gone very immediately and subscribed. Very easy to handle. And we have seen cases, people are saying it's not safe, the espionage is happening, data is going to the foreign countries. And I think Supreme Court, somebody has filed a suit in Supreme Court of India, one case is pending. What do you feel about these online platforms where we use meetings and all, and how it is safe and secure, and whether data can go to the foreign countries and they can misuse data for our infiltrating our right to freedom of speech and expression and right to privacy? What is your view?
Well, my view is that with the advent of coronavirus, a new kind of other disease has come up. My doctor's friend often jokingly calls this disease as webinaritis. There's so much of webinars happening all around us. Everybody has jumped onto the webinar bandwagon, and they don't even think about which particular platform to use. Anything is available is invariably used. But I believe that these kinds of webinars that are happening on platforms like Zoom have to be mindful of the terms and conditions and privacy policy of these service providers. For example, right now, today, we are doing this particular webinar on Zoom. This is governed by Zoom's privacy policy and terms and conditions. It actually will also ensure that Zoom will be able to have access to the same, though your intellectual property rights could be protected. But yes, please understand, this is ultimately data going outside the territorial boundaries of your country. It's going to the US or other distinctive servers. So the chances of this kind of data being potentially used, shared by various kinds of service providers along with various business partners cannot be ruled out. And also with now, for example, today's webinar is not just on Zoom, but also is being broadcast live on Facebook. Well, that means the broadcast which is live on Facebook is going to be governed not by Zoom's terms and conditions, but by Facebook's privacy policy and by Facebook's terms. And Facebook is very, very clear. It has no respect for your specific privacy. And that's why it's actually been using all your data for a very, very long period of time. So I think in case if you believe that you are dealing with very confidential data, then these kinds of platforms are not for you. But in case if you're dealing with just general information which is otherwise available in the public domain, like or public awareness mechanisms like this, then these kinds of platforms can definitely be kept in mind. I think primarily it was this very reason that the Indian government has been very, very, shall I say, concerned about the use of Zoom in governmental approaches, because all the data is ultimately going to US. There's also a connection of Zoom with China. So a lot of people were talking that the data is going outside. That's why the Indian government has now through CDOT come up with a new platform of a video conferencing nature, which they would be using for governmental operations and also for the judiciary activities. But ultimately, we will all have to start making a choices. Just because the herd is going in the direction of webinar, just because everybody else is doing the webinar, we should not do the webinar. We should at least read the terms and conditions of the relevant service providers so that we have substantial clarity as to how our data is being dealt with, handled, or processed by the service provider. Because in case if we are not going to be careful, it could have a prejudicial impact upon not just data protection, but also upon your privacy per se. I was in one of the Zoom meetings the other day, and it got invaded by somebody from Africa. They started showing all kinds of pornographic content. I'm sure this kind of Zoom bombing attacks, as what we call it, is something that what normal users would not really prefer in their meetings. So you will have to be careful that whatever platform you use must not only respect you and your data, but more significantly should also, as far as possible, be more cyber secure, so that your meetings or your deliberations could not be potentially hijacked by hackers or by cyber criminals. Thanks.
Thank you for very nice answer and a very elaborate answer to clarify the lot of doubts in the mind of the participants. The blockchain technology is coming in a big way. How it can help us to future developments?
Which one, Professor Tabrez?
The blockchain technology.
Okay. Blockchain, I believe, is the new fundamental mature technology that we've begun to start seeing. Blockchain is now not having the buzz, the kind of sexy sheen that it used to have a few years back, because it started getting more mature. It's increasingly now being adopted in different parts of the world. The government of Andhra Pradesh is already in the process of transferring almost all of its land records onto blockchain. It's since it's now a reasonable level of maturity, it's now increasingly going to be used in legal foundational terms in different parts of the world. I've seen blockchain laws effectively being passed in countries like Malta, Estonia, Switzerland, and we've also begun to see countries like Belarus coming up with specific legislations containing to blockchain. Further, a number of states in the United States of America have not only come up with new legislations that have granted legality to the concept of smart contracts, but more significantly, they've also stipulated how blockchain technology could be used by various stakeholders for a variety of their statutory functions. For example, in one US state, it's now legal for the chartered accountants to go and save their ledgers on blockchain technology and on public ledgers based on this particular technology. So I see a lot of promise of this technology. I see massive usage of this technology in electronic governance, related services, and a variety of finance, insurance, and other related activities as well. It's getting more mature, but right now is the stage where blockchain, while it's increasingly being adopted at a technical end, needs more enabling legal support from enabling legal frameworks in different parts of the world. If you're in Estonia or Malta, you can be rest assured because the law is taking care of the legal framework for blockchain. But in case if you were in a country like India, then expecting current law to protect you or to give you an enabling legal support for promoting blockchain would be a challenge, because blockchain is not neither specifically covered under the Information Technology Act 2000 or any specific legislation per se. But very issue.
Yeah. I think connection loss. Yeah, please carry on.
So I'm just saying that I believe there's a very massive future potential for blockchain, and I believe it will require more enabling support in the coming times. Thanks.
Okay, tell us about yourself. You are being the pioneer in the field of cyber law, and then you are almost part of all the international policy-making bodies, all the committees, whether it is UN or UNDP or ICANN and all. And you being in a very short time, you became the international figure. What inspired you to take this field and to choose as a area for practice and exploration? And you are really doing great job for the entire world, and supporting framing of laws, protection of the rights and liabilities is a great work you are doing. What inspired you to take this field?
Thank you, Professor Tabrez, for your kind words. Actually, I believe that you don't do anything on your own. There's a predefined script that is written for you, and you only go and follow that. I was a normal civil and corporate lawyer. I started my legal practice in 1988 in one of the district courts in Delhi. But clearly, I was very interested in technology. So when internet had come across in the year 1995 in India, I got fascinated by the said technology. 2 months there was madness because I said, look, this kind of a paradigm is going to be completely different. But after initial madness, I began to start realizing that the digital is the way of the future. And if you can start focusing on the legal nuances pertaining to this new technology, it can go a long way in the coming times. So I started focusing in that. There was massive pressure. My own father, who was also a lawyer, was not happy with me because he said, you're wasting your time. But I said, okay, let me start balancing my activities, but start focusing here as well. As time passed by, initially it was just e-commerce, then internet came in a big manner, then with the World Wide Web coming in, and with all kinds of electronic authentication mechanisms coming in, the field started growing. Initially, one was only into cyber law. Then one started realizing that cyber law was a different animal altogether. We initially thought that cyber law will just be one of those sector verticals or disciplines that will be there, and that's it. Like you have taxation, you have property law, so you will have cyber law. But I was very clear that as technology is going to grow very, very rapidly, you will need constant updation on not just of existing legal frameworks, but you will have to come up with new legal frameworks so as to support this technological paradigm. So I started concentrating here. Then mobiles came in a big manner. We saw the mobile revolution. We saw the dot-com boom. We saw the dot-com bust. So various phases, ups and downs started coming in. But I realized that technology is here to stay. And now with the lockdown coming in, almost massive developments have taken place in terms of digital adoption in India, which we could not have anticipated 6 months back. And I think because of the massive push towards digitalization, the world is going to be all digital. Therefore, I thought that let me start working in this space. I've been working, but each day has been a great learning day. And I feel that I'm still a student because every day when I wake up after my 8 hours of sleep, I wake up with a great sense of discomfort because in the last 8 hours, there are so many new developments that have been happening globally, and it's normally a big task to catch up. But yes, when you constantly are in the space, it's a fascinating space. You tend to get inspired. You tend to learn every day from technical stakeholders, from other stakeholders across the world. You ultimately look at it that the technology and the internet is a global paradigm. It's here to stay, and it'll be a heritage for us for all times to come. So if we can start contributing our own small, remarkable contributions to the growth of legal jurisprudence, that could be a good way forward. So it was primarily this particular thought processes that have kept me going on. And I believe that we still are very early days because today is 2020 May, and the cyber law developments are only at a very early stage. Because I believe if we were supposed to write a book on cyber law in 2050, and that book was to be of 100 pages, then by the end of May 2020, we would only have come to the 7th or the 8th page. So more than 90 plus pages have yet to be written. There's massive promise in the new jurisprudence that's likely to evolve. And I believe that the more you concentrate on this, the lesser it will be. Thanks.
I remember our first meeting in Vigyan Bhavan in 1995, 25 years back, and I was truly inspired because of you writing always in the Economic Times about the cyber laws and all. So even after our meeting, I decided my area to take a cyber law, and I did then LLM and PhD in cyber law, and very active blog writer. But I chosen the field of academics and chosen the profession. So in the short time, you grown like anything, and also it is great contribution to the world because we really require very strong cyber laws, regulations, and sometimes very challenging for the new lawyer to understand all the technicalities and also the legal aspects to provide the very good policy for the country. So great work you are doing. Please carry on your good works, and also please tell something about those faculty students who want to make as a career choice for cyber law, where they should focus and how they can start the process.
Thank you, Professor Tabrez. It's been a great journey together. We've been working for the last many decades together on cyber law, and it's great to have such inspiring figures like you as people who have been doing the journey with you together. It's a constant journey, but it's only a start every morning. Like today, new technologies have come in. So these technologies are requiring you to come up with new legal frameworks. For example, whether it's artificial intelligence, whether it's blockchain, whether it's Internet of Things, whether it's quantum computing. So the future is going to be very, very bright. So in case if you are a student or you are a faculty or you're somebody who's connected with the legal framework, then you have to quickly start realizing that the digital is the future. Yes, you will start going in your own distinctive fields. You could take civil, criminal, property, space law, sports law, whatever you require. But you'll have to quickly start realizing that there'll be a great interdisciplinary kind of an overlap between your respective discipline and cyber law. In case if you want to specifically focus on cyber law, I believe there's massive potential. Why? Because the world has only begun to start going into the digital ecosystem. In fact, more digital, shall I say, new entrants have started to come onto the digital bandwagon after the lockdown. Because when you were in lockdown, you had no other option but to be on the internet and communicate the word to the world using the internet. So if you're a student who's looking for future prospects, all I can say is the technology is here to stay. Cyber law presents a very, very exciting prospect for you as a student for a future. Now, you may slightly not have much clarity as to what line you want to go in cyber law. Now, cyber law, please understand, is also an evolving discipline. Initially, it was just a small discipline that was dealing with cyber legal issues, only pertaining to cyberspace. But over a period of time, it's now expanded so much that it today is covering almost any activity done using 7 raw materials that you use on a day-to-day basis. That's whether we use computers, computer systems, computer networks, computer resources, communication devices, as also data and information in the electronic form. So as you go forward, you're likely to see sub-disciplines that are likely to emerge under cyber law. So you can pick and choose any of these sub-disciplines. For example, artificial intelligence law is coming as a very, very important and promising sub-discipline. Cybersecurity law is a very, very significant area of sub-discipline of cyber law. Further, cybercrime law is yet another area. You could concentrate on the Internet of Things and connected legalities, because that's going to be opening up a new universe of legal Pandora box and issues that we are likely to be dealing with. You could also focus on quantum computing and the connected legalities, because that's going to come up in a big, big manner, because with quantum computer coming in and effectively even breaking all our passwords, it's going to be a different world altogether, which will require more enabling legal support. Similarly, with new technologies like blockchain coming in, you could specifically focus on the blockchain legalities. You could become a practicing lawyer. You could also become a cyber lawyer who could actually provide your services to various companies. Please understand that today companies require people, those lawyers as in-house counsels who know about cyber law, because they want to have a multi-skilled kind of an approach. So if you know more about cyber law, the chances of you being picked up as an in-house counsel are going to be far more as compared to any other candidate who does not know much about cyber law. Another thing, you could also use this particular area to get into the area of policy making, of advisories, of compliances, because please understand the legal processes and frameworks are only beginning to evolve. And if you can contribute in the evolution of the legal jurisprudence, that's a fascinating approach. You see, as lawyers and as legal students, almost all of us have one perennial complaint. We always say, look, we have to study history. Law was already been made. We can't do anything. So here is your opportunity. If you want to contribute in the evolution of jurisprudence, then I believe cyber law is a massive favorite, a de facto starting point for you. And even if you don't want to go into cyberspace, I'll still encourage you to focus on cyber law, because the interconnection between the law pertaining to the electronic format and your specific practice is going to be very valuable. Even otherwise, if you don't want to go into the law, you want to go into any other kind of advisories or consultation processes, I believe your knowledge or your awareness of cyber legal issues will be of massive existence. In case if you're into massive value, in case if you want to go into mergers and acquisitions, or you want to go to even criminal trials, everything is getting electronic. You will need to know the nuances pertaining to the electronic ecosystem and the evidence that's connected therewith. That's where cyber law again comes up. So I believe there are n number of opportunities. You have to pick and choose as a student what you want to do, how you want to do. And I believe the digital is the way of the present and the way of the future. The quicker we adopt it, the more focused we will be, and the better we will be as compared to other people who are not yet focusing on this area. Thanks.
Thank you, Dr. Duggal, for providing elaborate answer, and also we are really enriched and inspired by your great words. We are really honored and thankful to you for finding time from busy schedule and agreeing to deliver the webinar. It was great experience and very enriching experience. We hope to get you in our campus once the lockdown gets over, and also feel free to collaborate with you and for any kind of joint work in the area of cyber law, cybercrime, cybersecurity. Thank you very much. Thank you all the participants, and I thank our MD, Mr. Nipun Goenka, President, Mr. Suku, Registrar Dhiren Parihar, and all the faculty colleagues who have supported the coordination of the entire webinar. Thank you, all of you. Thank you, Dr. Duggal.
Thank you, Professor Tabrez. It's been a wonderful pleasure, an honor for me to be part of your initiative, and I'm happy to keep on working with you. It's been a great journey together as colleagues, and we look forward to continually working together. Thank you, and wonderful talking to all of you friends here. Thanks and good luck.
Thank you.